one. There's Ken. There's Matt. There we go.
Good morning.
Good morning.
Morning.
Morning, guys. Good morning, everyone.
Hey, guys.
There's Mikey.
Good
Yeah.
morning, Shannon.
I missed you guys.
We miss you.
I don't miss Mike, though. Just everyone else.
Me neither.
Keep paddling down that river called denial, Shannon.
Okay, now, so
He's such a fun.
first up, Dominic
Oh,
Toll.
let me put us on.
Can I ask Mr. Kelly a question before we start?
Uh-oh.
Sure, we are live streaming.
That's all right. Mike, will you look and see sometime what the date your divorce trial was or your divorce was filed, so I know who's first?
Yeah.
Mine was filed February 25th.
Okay.
This is Beaver Court, correct?
Yeah, in front of Susan.
Yes, or
Yeah.
Jordan. And Ken's the LGAL and his secretary. Mine's probably going to be adjourned because he doesn't think he's going to get his report done in time. So you may be the only one going.
Okay.
Yeah, I'm done now.
Okay, I'm letting Samantha Toll in.
The workers are Caitlin Kinder and Kimberly Erickson, Your Honor.
See, they're both here, and let's see, I'm looking for Devin Lemble. He's not in by that name. Anybody know? I've got a phone number waiting. Do you know his phone number?
It's 262-7307, I believe. I think
All right.
sometimes he calls from a different number.
That's the phone number I have for him, Your Honor.
All right, well, he might be in. I've got a couple of iPhones. Let me check.
Mr. Hotchkiss, I hear you're taking a once every 5-year vacation.
Yeah, it'd be a enjoyable 4 days, 5 days.
Oh, I thought it was longer than that.
Yeah, about 5 days.
Ma'am, on the iPhone, what is your name?
Carissa Cahey.
All right, I'm gonna put your name with this and put you back in the waiting room. Probably not spelling it right. And who is this on the iPhone that I just let in?
Brandon Rubloff.
All right, I'm gonna rename you so I know who you are, and then I'm gonna put you back in the waiting room.
Okay.
Brandon, give me your last name again.
Rudloff. It's Rudloff.
All right, I'll put you back in the waiting room, but at least I know who you are now. All right, I've got, let's see. One other device. I'm gonna see who's on that. It's a Galaxy. Does anyone recognize this gentleman?
Yes, Your Honor, that's Mr. Lemble.
Oh, okay, very good.
I do know last
Okay.
court hearing he had struggles to connect to his audio, so it might take him some time, Your Honor.
Okay, looks like he's connected now. Mr. Lemble, can you hear me? No, not quite. It looked like it was connected and then it, Mr. Lemble, can you hear me? Mr. Lemble?
It looked like there was an X, so it looks like it didn't connect the audio.
All right, what is his phone number?
It's 517-262-7307. I'm also texting him as well, Your Honor, to see if maybe his mute's on or something.
It keeps going between showing it connected and not connected. He doesn't appear to be able to hear us.
Right.
I'm just going to dial a number.
Hello?
Is this Mr. Lemble?
I'm sorry, what was that?
Is this Dominic Lemble?
Devin Lumble.
Devin, I'm sorry.
Yeah.
Okay, we're having trouble getting an audio connection, but we can hear you pretty good over the phone, so we'll keep this connection open.
Okay.
Could I have each of you identify yourselves for the record?
Matt Wade, Prosecutor's Office.
Devin Lumble.
Caitlin Kinder, MD, HHS, and author of this petition.
Rebecca McCluskey for Samantha Toll.
Kimberly Erickson, assigned foster care worker.
Ken Hotchkiss, attorney for Father Devin Lemble.
Ivan Brown, LGAL.
And I believe my client, Samantha, is also connected. Ms. Toll, if you're here, will you state your name for the record, please?
Samantha Toll.
Okay, she's here. All right, very good. How are we proceeding today, Mr. Way?
Your Honor, it's my understanding based on prior communication with Ms. McCluskey that the mother's going to enter a plea. I've provided a no contest basis to Ms. Carroll. Mr. Hotchkiss and I were talking about Mr. Lumble. We are, I think, ready to proceed to trial. There was an issue brought up that I guess Mr. Lumble previously signed an affidavit of parentage to become legal. There was at the same time a pending front of the court case. He actually did a DNA test to determine paternity as well. So I don't know if, my only concern is if the court, I guess, didn't adjudicate or did adjudicate but did not, or but wanted to return the child home. And then Mr. Lumble finds out he's not the father, files an action to revoke paternity, that we're kind of moving this kid back and forth. If he isn't, at the same time, if the court does adjudicate and he ends up not being the father and revokes paternity, he has an adjudication on his record unnecessarily. So I'll leave it up to the court. We are prepared to proceed, but I just wanted to raise that issue and I inquire the court as to how to best move forward.
I'm sympathetic with that concern, and as long as we can adjudicate with a plea from mom today, I'm willing to postpone the trial. Obviously, Mr. Lemble, you, because of the affidavit of parentage, you indeed are legally the father of this child. If there is a paternity test that rules you out as the father, you'll still be the legal father until such time as someone takes action to revoke that affidavit of paternity, which that action may or may not be successful. But just so you know that, I am fine today with proceeding with just mom's plea. That allows me to adjudicate the child, and then we can postpone it to dad until we know the outcome. Tests have been administered to the child and to Mr. Lemble, is that correct?
Yes, Your Honor, from my understanding, tests were done either probably about 2 weeks ago. I do know that the foster care workers reached out to the friend of the court office, and she hasn't heard back yet. So I know we are attempting to get the DNA test and the pertinent information to this issue.
Ms. Kimball, do you know how long it take?
I do not. I know that Miss Erickson is on the Zoom meeting, so she might be able to attest to that information.
Okay.
In my experience, it's not very long. It's usually 3 to 4 weeks, I think, that the
Okay, thank
DNA
you.
results come back.
Wonderful.
Okay, let's proceed. Ms. Toll will be giving a no contest plea today. And what's the reason for a no contest plea?
Potential criminal or civil liability, Your Honor.
Okay, Ms. Toll, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name for the record.
Samantha Sky Toll.
Ms. Toll, you are the mother of Dominic Toll, born August 20 of 2019.
Yes, Your Honor.
And was Dominic located in the county of Jackson when the petition was filed?
Yes, Your Honor.
If the court accepts your plea today, there will not be a trial, and therefore you would be giving up all of the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove you can put your hand down now.
Okay.
The right to have the petitioner prove the allegations in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to testify on your own behalf, and the right to have the court subpoena witnesses who you believe would testify in your favor. Do you understand that you will be giving up all of these rights if I accept your plea today?
Yes, Your Honor.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your child a temporary ward of the court, place him with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your son with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Excuse me. Do you understand each of these consequences?
Yes, Your Honor.
If your parental rights are later terminated, your obligation to support your child will continue until a court modifies or terminates the obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and that challenge can include any issues leading to the disposition, including errors in the adjudication. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions about anything I've told you so far?
No, I don't.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No.
Are you entering this plea of your own free will?
Yes, I am.
And do you understand that I will treat your no contest plea the same as I would an admission of responsibility?
Yes.
Okay, I have been provided with an excerpt from the CPS report, which I marked as Plaintiff's Exhibit 1. I'm going to take just a moment to review that to myself. All right, I have reviewed plaintiff's exhibit 1. Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes,
Yes,
Your Honor.
I do accept the plea. I find that it was knowingly, understandingly, and voluntarily made. And I find that the record supports that one or more of the statutory grounds alleged in the petition are true. Are we prepared to move forward with disposition today?
We are, Your Honor.
Ms. Erickson, do you have recommendations for disposition?
Yes, Your Honor, I do. So,
Could you give us those?
yes. It is recommended that Dominic remain in the care and custody of MDHHS, that Dominic remain in relative placement, that Samantha participate in parenting times, that Samantha participate in parenting classes, Samantha to complete a psychological assessment and follow recommendations, Samantha to complete drug screens given by MDHHS or another service, and Samantha to sustain appropriate housing and employment. And I do want to add, Your Honor, that Samantha has voluntarily and gladly participated in all recommended services so far.
Good. That gets us off to a very good start. And I'm assuming, what is the recommendation for the father's parenting time?
I do recommend that Devin participate in parenting times and parenting classes. That he.
I can't order any services for him because we're not adjudicating as to him today, but I wanted to know what you were recommending for his parenting time.
I do recommend that he participate in parenting times at least once to twice weekly.
Supervised or unsupervised?
Oh, sorry, supervised. Sorry, Your Honor.
All right. Counsel, do any of you wish to be heard regarding the recommendations?
Your Honor, I would, on behalf of Ms. Toll, there are, unless I've missed something, there are absolutely no allegations about any sort of drug use. So we would object to the drug screens. I think that's kind of overreaching. She's, as the agency's agent already stated, she has participated in a psychological evaluation already, and we expect those results any day. So we would ask for discretion to go to unsupervised pending those results if the agency finds it appropriate based on Dr. Lauder's psychological evaluation. Thank you.
So I know a drug assessment and screens are almost routine. Do you have any reason to believe that Ms. Toll is using illegal substances?
There was, in the investigation, there was some concern with drug use, but so far, Samantha has participated in 6 drug screens and they have all shown as negative. So I would be glad to end drug screens at this time.
All right.
Thank you.
We'll remove that requirement. There will be no responsibility for screens or an assessment for mom. Otherwise, the recommendations appear appropriate to me, so I will include them in my order of disposition. Let's set another pretrial and trial for Mr. Lemble. Why don't we set the pretrial in 4 weeks and then the trial 2 weeks after that, Shannon? Excuse me.
September 9th at 8:30. And the trial will be September 23rd at 8:30.
Did everybody hear those dates and times?
Yes.
Yes, Your Honor.
Yes. I'd like to add,
What was the time on the 23rd?
8:30.
Okay, thank you.
And then mom's review hearing is November 3rd at 9:30.
Erickson, I am just wondering, with regard to Mr. Lemble, I think you said supervised by the agency or his discretion. After reading the petition, I'm just wondering, what are the concerns with regard to Mr. Lemble?
Concerns regarding Mr. Lemble would be the other case that he is involved in and the lack of participation in services. I will say that he, at this point, has participated in parenting times at Lisa Lemble's home. He has, and they've been positive reports.
What other case is he involved in? I'm not aware of that.
From what I understand, there was a case with him and I believe his girlfriend that included domestic violence. I believe that was in the petition.
Okay.
And if I may be heard on that as well, Your Honor.
Go ahead, Mr. Hotchkiss.
Your Honor, I've discussed that with my client. I've also discussed this with Mr. Way. I don't think, I don't believe there's going to be anybody that can put forth any proofs that that domestic violence incident occurred. In fact, I can even present a witness, both of the parties alleged in that incident. The case against my client's extraordinarily weak. I understand the prosecutor and agree with the prosecutor's comments this morning with respect to developing a bond and so forth in the event of a revocation of paternity, and I understand all that. But really, there is nothing in this petition that I think prohibits my client from really unfettered contact with this child. I think at first glance, I'm not even real sure why he's even a respondent, and I was somewhat well, let's just say that I was hopeful that this court wouldn't even take jurisdiction, even understanding the low burden. So from now until our trial date, I haven't heard anything that would suggest that this child would be at risk with Mr. Lemble. Thank
I would have no objection to giving discretion for unsupervised with Mr. Lemble as well. And I certainly think that, because I believe the child is with his mother or his parents, and that I have no problem with them supervising so he can see the child more often than, the traditional once or twice a week.
Given that the child is with his parents, I would assume he would be afforded significant parenting time based upon what his parents are willing to provide, which I think will provide an ample opportunity for a bond. I will give discretion for unsupervised as well.
Thank you, Your Honor.
Thank you, Judge.
Okay, Shannon, did you give us a review hearing date?
Yep.
Everybody get that?
Yes.
Yes.
Yes, Your Honor.
Okay, very good. I think that concludes this matter. Thank you very much.
Thank you.
Okay, Mr. Lemble, our hearing's over. You're free to leave.
All right. Thank you very much, Your Honor.
You're welcome. Oops. All right, next up is Rudloff. So let me see who's out in my waiting room. Who's the worker, workers, Mr. Way?
Jade Blair is the worker. And the two parents are the parents that you changed the names to, Cahey and Rudloff.
Oh, okay.
And then there may be some officers. I'm not sure if we're having a trial, but there may be some officers in the waiting room as well.
I'm sorry, Mr. Way. I'm locked out of my emails. My client is going to enter a plea.
Okay.
And Mr. Kelly, how about your client?
Your Honor, I sent an email to Mr. Way the other day because we had discussed at pretrial, considering kids are in home with him and he's voluntarily already participating in services, whether it was necessary moving forward, making him a respondent at this time. I just hadn't heard back.
Yeah, and I apologize, Mr. Kelly. Things got a little crazy yesterday, but I did hear back from the agency at the end of the day, and they do wish to pursue Mr. Rudloff as a respondent for now.
There was some sound interference. I didn't hear exactly what you said, Mr. Way.
The agency does wish to pursue with Mr. Rudloff as a respondent for now, Your Honor.
Okay, thank you. So is that going to be a trial?
No, Your Honor. When I had last talked with him, it indicated that if the agency was not willing to make him a non-respondent, we would simply indicate to the court that within the home there has been some drinking and some domestic violence. With not saying that he was a perpetrator of domestic violence, but unfortunately he was involved with it. Essentially as a victim of domestic violence, and it did occur with the children physically in the home.
Okay, so both parties will be making pleas of admission today then?
Yes, in accordance with what I just did to you, Your Honor.
Okay, could I ask Ms. Cahey and Mr. Rudloff, would you each raise your right hand? Do you each swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Rudloff?
Yes, sir.
Ms. Cahey?
Yes, Your Honor.
Okay, you can put your hands down. Are you the parents of Kaylin? Yes.
I apologize. I don't, sorry to interrupt. Because there is a criminal matter pending, I would prefer that my client enter a no contest plea. Mr. Way, is there any way that you have access to the dispo findings from the 154?
I'm sending it over to Shannon right now.
Okay, thank you. I apologize. Thank you, Your Honor.
Because of potential criminal responsibility, I will accept a no contest plea from the mother.
Thank you.
Can you confirm that you are the parents of Kaylin Rudloff, born October 23 of 2017?
Yes.
Yes.
Mr. Rudloff, we seem to be picking up some vocal interference from your end. Is there something in the background that's playing?
No, there's not.
Is it on speaker by chance?
Yes, my phone's on speaker.
Okay. And I'm sorry, Mr. Rudloff, you are the father of Kaylin?
Yes, sir.
And you're also the parents of Bryson Rudloff, born September 20 of 2018?
Yes, sir.
Yes.
If the court, I'm sorry, was each child located in Jackson County when the petition was filed?
Yes, sir.
If the court accepts your pleas today, there will not be a trial, and you would be giving up all the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you.
Excuse me, Your Honor, could you repeat those? You were cutting out.
I can. If the court accepts your plea, there won't be a trial. You will be giving up the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury. the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you each understand that you will be giving up these rights if I accept your plea today?
Yes,
Yes,
sir.
sir.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your children temporary wards of the court, place them with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your children with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you each understand these consequences?
Yes, sir.
Excuse me. If your parental rights are later terminated, your obligation to support each child will continue until a court modifies or terminates the obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition after adjudication, and that challenge can include any issues leading to the disposition, including errors in the adjudication. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do either of you have any questions about anything I've told you so far?
No, sir.
No, sir.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No, sir.
Are you entering this plea of your own free will?
Yes,
Yes,
sir.
Ms. Cahey, do you understand that I will treat your no contest plea the same as I would an admission of responsibility?
Yes, sir.
Okay, I've got a factual basis as to Ms. Cahey's no contest plea, which I will take a moment to review. It's been marked as plaintiff's exhibit 1. Mr. Kelly, could you please establish a factual basis for Mr. Rudloff's plea?
Mr. Rudloff, would you agree that Child Protective Services got involved with your family right around January of 2020 this year?
Yes, sir.
And they've been involved with your family on and off since that time up to present?
It's been continuous since then.
Okay. Was part of the issues during that time because of some drinking that was going on at one point in time where you actually had a PVT result of 0.13? That was back in January.
Yes, sir.
And was there also some domestic violence that occurred within the home during that same period of time?
Yes, sir.
And even though the children may have not been actually physically present to witness it, were they physically present within the home while some of these things were occurring?
Yes, they were.
Okay. I don't believe there's anything else further, Your Honor.
And I'm still reading Exhibit 1. It would appear that God was watching over Bryson that day. It's amazing he wasn't seriously injured. I have read Plaintiff's Exhibit 1. Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
I am satisfied with both pleas. I accept them. I find that they were knowingly, understandingly, and voluntarily made. And I find that the record, which includes Plaintiff's Exhibit 1, supports that one or more of the statutory grounds alleged in the petition are true. Are we prepared to move forward with this position this morning?
Yes.
What are the recommendations for disposition?
For Carissa Cahey, the recommendations for right now are supervised visits by DHS or designee, random drug screens by DHHS or another agency, specifically looking for alcohol specifically, and the psychological evaluation for her to participate in substance abuse treatment, which includes counseling services. For Brandon, random drug screens by DHS or its designee, continue with counseling services, specifically regarding substance abuse. He's already working with Donna Richardson, and so is Carissa. That should be noted.
Great. I'm glad to hear we're off to a good start. Either counsel wish to be heard concerning the recommendations for disposition?
No objections, Your Honor.
And Your Honor, those all sound standard to me. I have no objection. We would just ask that if, I know there was some talk about the father being removed as a respondent, if the agency finds it appropriate, obviously that the parenting time is supervised by the agency or its designee. We're hoping that the father can be the designee if the agency finds it appropriate during this first reporting period. Otherwise, no objection.
All right, and I will, obviously, children are with the father. I will give discretion for the agency for supervision by a designee. Shannon, what do we have for a review hearing date?
November 10th at 9.
November 10th at 9 o'clock. Ms. Cahey.
Yes, sir.
I am so thankful for your sake and for your child's sake that neither one of you were seriously injured. Unfortunately, when things like this happen, that usually isn't the outcome. I hope this is exactly the wake-up call you needed.
This
and
is
I wish you
exactly
well.
it.
I'm so glad you're off to a good start, and I hope you continue on this track, man. Good luck to you.
Thank you so
Mr.
much.
Rudloff. Okay, I think we're done with this one. Thank you.
Thank you.
Your Honor, are there some officers in the waiting room?
Deputy Walbrock.
Yep. He's the one away.
And, I've got a Todd Waite.
He was on the toll case, so yeah, if we could bring him in too.
And Brandon Holler.
He's on a later case. Deputy Wolbrock. We just the parents, the mother just entered a plea, so your testimony is not going to be needed.
Okay.
Thanks for appearing though.
Have a good day.
You need something?
You too.
from me?
Huh?
Did you need something?
No, I just said, oh my God, that feedback.
Oh, yeah. All right. I know where it's coming from. Will.
Trooper Wade, can you hear me?
Yes, can you hear me?
Yep, I sent you a message. I don't know if you got it though. The mother entered a plea, so we don't need your testimony this morning.
Okay, sounds good. Thank you.
Thank you.
Thanks.
Okay, next matter then is the
Hello?
Holler Jackson matter.
I think we have the Christian Gibson matter still, don't we?
Oh, you're right. I skipped that. Pardon me. Christian Gibson.
And I requested Dad from jail for the polygon.
Okay, we're gonna have to call over there and see what's going on. I don't see that they've dialed in yet.
Am I all set to leave, Your Honor?
Yes, you are, ma'am.
Thank you.
You're welcome. Okay, yeah, who else is on this file, Matt?
Ivan Brown. Sorry.
On Gibson,
That might be in the waiting room.
Ms. Blair's the worker on this one as well, I believe. The mother's Courtney Whitney.
Okay,
Represent her,
let
Your
her
Honor.
in. All right, and I've got an iPhone. I'm gonna see who that is.
Oh, that's another one of
Is
my
that
officers.
Guys, are we gonna need him or?
No, Officer Brooks.
Yeah, can you hear me?
Yep. So the parents just entered a plea on your case, so we're not going to need your testimony today.
Perfect. Y'all have a good evening or day now.
Thank you.
Okay, and Ms. Dankey's on the next case.
Yeah, she's on Holler Jackson.
Okay, and those are the only two left there, so it looks like we've got everyone here. We're still waiting for Ms. Whitney to make a connection. It seems she's having trouble establishing an audio connection. Ms. Whitney, can you hear me? Do we have a phone number for her?
Yes, Your Honor. Her phone number is 517 507 8071.
Ms. Whitney, can you hear me? All right, I'm going to dial her number then.
Disconnected.
Oh,
I see that. Ms. Whitney, can you hear me?
looks like she's muted.
Ms. Whitney, can you hear me?
I can hear you now, yes. I couldn't figure out how to get the video unmuted.
All right, I just muted her, or muted her dog, I think. Okay, has everyone entered their appearances already?
That way, prosecutor's office.
Jade Blair, DHHS.
Hello?
Mike Kelly on behalf of Miss Whitney.
Ms. Whitney is present.
Yeah.
Ivan, on behalf of Shane Gibson, father.
Rebecca
And are
McCluskey, guardian
we-
ad litem.
And are we expecting Mr. Gibson? He's not in the waiting room. Do we have a phone number for him or? Oh, he's in jail. Yeah, thank you. We're gonna have to call over to the jail and find out what's going on. Is he next door?
I will have to.
I'll find out. Why won't it let me dial that extension? Well, I wrote down Wesley booking as 7512. But I'm not
Probably
getting
because it's 7912.
7912. That would explain it. And what's his name?
Shane.
Yes, this is Judge LaFlamme. Do you have Shane Gibson available for a court hearing?
I can. Just a second, sir. I'll get logged in for you and then have them ready for you.
All right, do you have my Zoom meeting ID?
Yes, I do. 929-993-7935.
Okay, thank you.
You're welcome, sir.
All right, as soon as we get Mr. Gibson signed in, we will move forward.
Have you had a chance to talk to Mr. Gibson since the pretrial, Mr. Brown?
I have not. I think he's been at the Wesley Street address.
Once he gets in, would you like me to put the two of you in a private meeting room so you can talk?
I'll try.
Okay.
Would you put some down in the washing machine if it's ready?
Did he say Downey?
You did?
I didn't think for sure.
I wouldn't do his laundry.
You put some down. It makes my sheets smell very nice.
Mr. Brown.
Ivan, I miss you so bad.
Same here.
I miss you guys too. But I would miss being on a ventilator even less.
We won't give you the Rona, Mr. Brown.
You don't ever know.
I do live with a bunch of germ carriers, so you're right.
Okay, looks like we've got a connection to the jail. Let's see. Is Mr. Gibson present?
Just a second, sir. I'm getting it right now for you.
Okay, thank you.
Judge, I only have one question to ask him, so I will be 60 seconds.
Okay.
I don't know how to get out of the waiting room if you put me in one.
I can cancel it. But I think you have a command that will show up.
Okay. I've done it once before, but I don't remember.
Yeah, there's a button, I think, that says leave the waiting room.
Okay.
And once I assign the two of you to the waiting room, you'll also have to click a button in order to go in.
Okay.
Okay. You are Shane Gibson?
Yes, sir.
Good morning. Okay, I'm going to put you and Mr. Brown, your attorney, into a private meeting room where the two of you can have a confidential conversation.
Okay.
You may have to hit a button that shows up on the iPad that'll put you into that room. And then once you're done with your conversation with Mr. Brown, there should also be a way for you to get back out of the breakout room, okay?
Okay.
All right, I'm going to put you in there now. Well, so far so good. Seems a little odd to be putting a jail inmate into a breakout room. So, Mr. Way, what are you going to do this fall?
Hopefully golf on Saturdays and watch old games on YouTube. I can actually watch Michigan beat Ohio State this fall if I pull up the right games.
Is the
I just want it to be over.
Is the SEC and ACC still moving forward?
And the Big 12. I bet the
And
ACC.
the Big 12?
Yeah, I bet the ACC will cancel. They have too many big research-based, good academic schools that I think will probably push to cancel, but you know the SEC is going to try it.
Oh, yes.
Like Ohio State and Nebraska are already complaining. Those people don't know what to do if they don't have football.
They were saying how Ohio State was trying to see if it could jump into a conference or play a conference schedule of one of the conferences that was still going to be participating, which is absurd.
There might be some contractual issues there, I think.
You'd think so.
Games won't be on TV.
I don't understand why they couldn't have given all of the players face shields. I mean, I've seen them in football helmets before.
You know what? My thought is, I think the NCAA has kind of screwed it up for themselves all these years, where they're saying the players they're not willing to give the players any sort of agency, and then that's been my biggest issue. The pros can collectively bargain and take the risks. You're forcing it on the kids, and it's a different ball game, I think. So I don't know though. It's gonna be weird not having Michigan football.
I hope to get a lot of projects done this fall now that my Saturday afternoons have become available.
Yeah, I should probably do that too. Got a lot of painting to do.
Speaking of painting, that's what this is like, watching it dry.
Can be.
So anybody want to take bets on whether or not Ivan's going to figure out how to break out of the breakout room?
You're probably gonna have to admit him again.
He's pretty crafty.
You know, he's done better than I thought. I think we've all done better than I thought we would with all of this.
He hasn't figured out how to rename his wife's iPad, though.
I can't. It just kind of blows my mind how people have not figured out to put their names on their devices. Like,
When I get attorneys on, I usually chide them if they haven't. You know, when we have motion day and I've got a bunch of people sitting out there,
yeah.
and it says iPhone or it says iPad or, you know, whatever, or maybe it's got their kid's name on it.
Okay, he should be here momentarily.
Yep, I see that. Congratulations on breaking out of your breakout room.
Okay. I think he was addressing that to me.
We were taking bets, Ivan.
You know, I am smarter than some trained chimps.
How does your client wish to proceed today, Mr. Brown?
Judge, we will enter a no contest plea, seeing that Mr. Gibson cannot take custody at this particular time in his current situation, and he cannot provide care and custody with him while incarcerated.
Okay, and Mr. Kelly, your client is entering a plea today as well?
Yes, Your Honor. The children are home with her, but she'll admit that during the question that there was an issue with domestic violence and drug use within.
And what will I be able to use for?
I will send Ms. Carroll the dispo findings right now, Your Honor.
Okay. So Ms. Whitney and Mr. Gibson, I need you to have you each raise your right hand. Do you each swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir.
Okay, sir, would you state your full name?
Shane Kelly Gibson.
And Ms. Whitney, would you state your full name, please?
Courtney Ann Whitney.
You are the parents of Christian Gibson, born September 10 of 2013?
Correct.
Sir, can you acknowledge for me that you are Christian's father?
Yes, sir.
Was Christian found in the county of Jackson when the petition was filed?
Yes.
If the court accepts your plea today, there will not be a trial, and therefore you would be giving up all of the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you each understand that you will be giving up these rights if I accept your plea today?
Yes.
Yes.
Excuse me. If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they might be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your child a temporary ward of the court, place him with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your child with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do each of you understand these consequences?
Yes.
Yes, sir.
If your parental rights are later terminated, your obligation to support your child will continue until a court modifies or terminates that obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and that challenge can include any issues leading to the disposition, including errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to obtain court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do either of you have any questions about anything I've told you so far?
No.
My son's not being taken away from Courtney, correct?
No.
Okay.
That is simply a consequence that could happen in the future if something more happens that would require a removal. That's not something that's going to happen as a result of actions today.
Okay. All right.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No.
No.
Are you entering this plea of your own free will?
Yes, sir.
Ma'am?
Yes.
Courtney will be all right till Christmas.
Mr. Gibson, has anyone, I'm sorry, do you understand that I will treat your no contest plea the same as I would treat a plea of admission?
Yes.
Okay, Mr. Brown, if you could, I'm sorry, Mr. Kelly, if you could establish a factual basis for your mother's plea while I'm waiting on a basis for the father's.
Yes, Your Honor. Ms. Whitney, is it fair to say that calendar year starting at about February 24th of 2020 that Department of Health and Human Services has been involved with your family?
Yeah.
And would you say during that period of time early on, when administered a couple of drug screens, you had tested positive for amphetamine and methamphetamine?
Yeah.
And it's also true during that same period of time that you ended up getting a personal protection order against Mr. Gibson?
No, we've had an active PPO for years.
Okay, is that still active?
Yeah.
And is that in part due to the domestic violence that occurred within the home?
Yes. Well, not this house. I think our first PPO was back in 2014, which was it resulted from domestic violence at his parents' house, and then as well as the house I was living in, Spring Arbor.
And during the time that these things were happening, children may have not directly witnessed it. Were they physically present within the home?
No, not every time.
But sometimes they were?
Yeah.
Okay.
Nothing further, Your Honor.
Okay, I have received dispositional findings from the CPS report marked as Plaintiff's Exhibit 1 to provide a factual basis for Mr. Gibson's plea. I'm going to take a moment to review it to myself. Okay, I've completed my review of the exhibit. Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your
Yes, Your
Honor.
Honor.
Yes, Your Honor.
I accept both pleas. I find that they were knowingly, understandingly, and voluntarily made. And I find that the record, including plaintiff's exhibit 1, support that one or more of the statutory grounds alleged in the petition are true. Are we prepared to proceed with disposition today?
Yes, Your Honor.
What are the recommendations for disposition?
For Courtney Whitney, the recommendations are for her to start counseling services, and the referral for that has already been made. Complete a substance abuse assessment, random drug screens by DHS or another agency, and complete a psychological evaluation. For Shane Gibson, he would have supervised visits by DHS or its designee, complete a psychological evaluation as well, counseling services for him as well in regards to the domestic violence incidents that's happened, complete a substance abuse assessment, and have random drug screens by DHS or another agency.
Counsel, do you wish to be heard concerning the recommendations?
Yes.
Go ahead, Mr. Brown.
Judge, with regard to supervised parenting time, I'm a little dismayed why we would request supervised parenting time for Mr. Gibson and the child still remains in the home. The allegations with regard to mom are far more egregious than they are as to father, so I'm a little confused by that. Secondly, with regard to the substance abuse evaluation, in the report, my client indicates that he has not did drugs since 2018. Is that correct, Mr. Gibson?
Yes, sir. I was going. Never mind.
So I don't know what the random drug screens are for. I believe a test was given recently. If that test came back for some illegal substance, then that would be different. But he was given a test while this case was being investigated. In the report, it says it was given to him, but I don't see where a result was ever in the report. So I suspect it was negative since it wasn't put in the report. So there's no reason for him to have supervised parenting time if mother has unsupervised or has placement. It just doesn't make sense.
That's the last custody order was it has to be supervised visitation.
Could I respond, Your Honor?
Yes.
There is a reference in the petition to Ms. Whitney disclosing that Mr. Gibson has a more significant problem with drugs than her. I acknowledge Mr. Brown's points about the results, the drug screens. I would also note too that Mr. Gibson appears to be in jail on a possession of meth charge, offense date 7/30 of 2020. So to me, that supports at least that we need to do a substance abuse assessment when he's released. Thank you.
Yes, and actually, I can talk on my behalf right now because yes, I am incarcerated on meth charges, but I just purchased them and I was on my way to go do them and I never got to my destination to do them. Thank you. So I don't know who Mr. Matt you are, but I'm still fighting that case. So that's irrelevant of what we're talking about today. Today we're talking about my son, not
I'm the prosecutor who just heard you admit to the crime.
Mr. Gibson, you just made admissions in your criminal case that I wish you had not done.
In any event, I've heard enough that I believe those recommendations are appropriate. Mr. Kelly?
Yes, Your Honor.
Did you have any objections to any of the recommendations?
No, Your Honor.
All right, I believe, based on all I've heard today, that the recommendations are appropriate as to both parents. Shannon, when will we do our first review hearing?
November 10th at 9:30.
November 10th? at 9:30. Thank you all. That concludes our hearing.
Thank you.
Oh, Mr. Way. Oh my.
It's always one of George's clients too. I gotta send George an email.
You can't fix it. You cannot fix that. I don't know what to do.
You remember his client who was charged with like GBH? I think it was Rebecca's client, and he gave like a long-winded apology in the courtroom to the victim.
I don't need a drug assessment because I got arrested before I got a chance to do the drugs.
Yeah. We had
It's
a
like a
case.
reality show.
We had a Judge Rapley case. We had a Judge Rapley case where the defense was that they don't use drugs; they just sell them.
I need to take a short break. I'm going to let the next two in. You could take us off the record, Shannon. What? 6 unassigned participants. What the heck is that? Oh, that's the breakout room. All right, Ms. Danke, I'd let you in, and Mr. Holler, but I've got to take a very short break. I'll be right back. We are not on the record, but we are live streaming, just so you know.
Thank you, Judge.
Did you need to talk to me, Susan?
Well, that was priceless. Okay, Shannon, you could put us back on the record. Okay, next up is Vala Holler Jackson. Looks like we've got, oh, I've got one person waiting. Let me let Melissa Taylor in. Okay, it looks like everybody is now present. Could have each of you identify yourselves for the record?
That way, prosecutor's office.
Susan Danke on behalf of Brandon Holler.
Rebecca McCluskey for Angela Stewart.
Ivan Brown, LJL.
Melissa Taylor, Department of Health and Human Services.
Okay, how are we proceeding today?
Your Honor, I believe we're conducting a trial as to the mother. Ms. Denke previously requested a jury trial. The discussion at the pretrial was that I believe Ms. McCluskey represented that the mom wishes to have her rights terminated or wishes to release her rights. And so we were just going to run a quick trial as to her.
Okay.
That is correct, Your
Anything
Honor. She
else?
did authorize me to let. I'm sorry. That is correct, Your Honor. And she did authorize me to let the court know that. Thank you.
And she does not wish to participate herself today?
She does not. When I spoke to her at length, she did not want to participate, and I did attempt to reach her again yesterday, and I could not reach her. So.
Okay, very well. We will proceed. Mr. Way, call your first witness.
Thank you, Your Honor. I would call Mr. Holler.
Can you hear me?
Yeah, Mr. Holler, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name for the record.
Brandon Scott Holler.
Go ahead, Mr. Way.
Thank you, Your Honor. Mr. Holler, you are the legal father of Vala Holler Jackson, date of birth 5/20/2009. Is that correct?
Legal and biological.
And is Angela Stewart or Angela Halsey the mother of Vala?
Yes.
At the time the petition was filed, was Vala found here in Jackson County?
Yes.
When is the last time that Vala's mother has seen Vala?
From what I know, she was a little over 2 years old. It was Thanksgiving, and her mother had came down to a Thanksgiving party that her sister was throwing, as where Vala was placed and visiting during that time, and it wasn't, and that's all that I know. So as far as that, I guess 8 years ago.
Okay, and so around the time that Vala was 2, Angela basically dropped Vala off at her parents' house. Is that correct?
It was younger than that, but yeah, she showed up, and as far as I know, was gone for a few months. And I found out about Vala through contact of her, I think it's mother or foster mother, one or the other.
Okay, and so when you find that out a few months later, did you take steps to obtain custody of Vala?
I did.
And when did you get full custody of Vala?
I got full custody a little after she was 18 months old.
Okay.
So,
So her mother hasn't seen her since at least before she was 18 months old. Is that correct?
no, she was a little after 2. She saw her then.
Okay.
She was down visiting, and then she came over, but I wasn't aware of it. She's not supposed to be around her without me knowing through court papers. So
Vala has not been in her mother's care since she was less than a year and a half old. Is that fair to say?
Yes, sir.
Okay. The entire time that you have had Vala, has her mother provided any child support to you?
No, sir.
Has she sent any Christmas presents, birthday presents, cards, anything like that?
Not that I know of, none to me. If they came anywhere, they would have went to her sister, but I didn't know about that either.
Does Vala have any sort of bond with her mother as far as you're concerned?
No, her sister actually told her children that she adopted, who were Angela's children, to now refer to her as Aunt Angela and not mother anymore.
Do you believe that it's in Vala's best interest that her mom's rights are terminated?
Yes.
Do you believe that that Vala would even be able to pick her mom out at this point?
I think she might have seen a picture of her from her aunt, Rita, but as far as knowing her voice or anything like that, no.
Okay. I have nothing further, Your Honor.
Anyone else have questions for Mr. Holler?
Just briefly, Judge.
Go ahead.
Mr. Holler, do you still have the same phone number that you had back when, when your daughter was 1?
Yes, I do.
So her mother does have a way to reach you and has periodically had contact with you.
She's contacted me twice. Yes.
Okay. Thank you. I have no further questions.
Looks like Mr. Brown left the room. And Ms. McCluskey, did you have any questions?
No questions, Your Honor. Thank you.
All right, any redirect, Mr. Way?
No, Your Honor.
Any further testimony?
No, Your Honor.
Any presentation from anyone else?
No, Your Honor.
No, Judge.
And for the reasons that I've already stated, I have no presentation. Thank you.
Can we dispense with arguments?
Yes.
Yes, Your Honor.
Yes, Your Honor.
All right, the testimony from Mr. Holler establishes clearly and convincingly that Vala's mother, Angela Stewart Halsey, has abandoned her, has not had custody of the child since she was approximately 18 months old, and has, it sounds like, made one attempt to see the child since then. Clearly establishes a basis for abandonment. That is, give me just a second to find my petition. Well, and before I get to termination, I should adjudicate. Clearly, this mother has neglected to or refused to provide proper and necessary support, education, etc. And has abandoned the child, which indeed provides a proper basis for both adjudication and termination. A termination basis is MCL 712A 19B3A II has deserted the child for 91 or more days and has not sought custody during that period. I also find that termination is in the child's best interest. The child would have difficulty even recognizing the mother since she's had no contact with her for so many years. There's no bond, and for this reason, I find it is in the child's best interest to terminate the mother's parental rights. And I guess.
So am I sending a post term, or are we gonna keep?
Well, there's no post term because we've got dad unadjudicated, and we don't know when we're going to be able to adjudicate as to dad. I don't have any way of predicting when it's likely we'll be able to do a jury trial again.
Judge, I can tell you we currently are scheduled for a jury trial October 20th. I believe Judge McBain has a couple jury trials scheduled in August. And I think there are a couple judges with jury trials scheduled in September. So we'll see how those go. But at least there's some scheduled prior to our October date.
All right, well, we'll keep that October trial date on. I think we really don't have anything else to do here except wait for that trial date. We don't do a post-term because we still have a parent in the picture. We can't do a disposition the disposition to mom, as to mom is terminating her parental rights. I think I am required to do a permanency planning hearing, but I think I've got a long time in which to do that. Give me just a second to look at my time guidelines.
I'm wondering if we don't set up a pre-trial maybe, just to kind of track how things are going.
There's one on the
is there?
schedule already.
I believe it's for the 12th.
I don't have it in front of me right now, but I can't imagine we set a trial without setting a pretrial.
Pre-trial set for the 12th and trial set for the 26th.
We go. Thank you, Mr. Holler.
Oh, there we are. Okay, thank you.
The trial's actually, I think, set for the 21st, and you had said, we just got a new notice for October 20th, Mr. Holler, they haven't sent to you, which I'm assuming is the picking a jury at 1 o'clock on October 20th.
Fantastic.
Yes, October 6th at 8:30 for the pretrial, October 20th at 1 p.m. for the trial. So let me see. I think the only thing I'm required to do is a permanency planning hearing, and I think we can go as much as a year without doing that. Let me just find it. I don't want to miss something and jeopardize funding if funding's going to be an issue. It's a bit of an unusual situation. Well, I won't hold you all hostage here. I will verify, but my best recollection is a permanency planning hearing needs to be held not less than once every 12 months. I think that's going to be the only kind of hearing that would be required. I want to verify that, but there really isn't anything else for us to do while we're waiting for a trial date. If there is a need for me to schedule a hearing, Shannon will get a hold of you and let you know. Otherwise, next up will be the pretrial.
Thank you, Judge.
Thank you, Renee.
Thank you all. That concludes our hearing. Have a good day, everyone.
You too.